There is apparently a concern on your side, Mr. Chairman, about whether you have on your side of the aisle access to all the information that we have on this side of the aisle and all the information that's in the possession of the White House. During a break earlier today, I met with the ranking member, Senator Grassley, his staff, and with White House staff to discuss it. Here's my understanding of what has transpired. Last Wednesday evening, the senator from Missouri selected a handful of Judge Jackson's more than 1,000 district court cases to claim that Judge Jackson, quote, endangers our children, close quote. On Thursday, the next day, the White House contacted Judge Jackson's chambers to request the probation office recommendation in each of the cases. I underline probation office. That probation office provided a chart reflecting these recommendations. This is the sum total of what was provided. They shared with the White House from the chambers. When the senator from Missouri continued to raise questions and request the probation office's recommendation in these cases, the probation office provided this chart reflecting those recommendations, which was shared with the White House. When the senator from Missouri continued to raise questions about Judge Jackson's sentencing record, my staff asked the White House for information about the probation office recommendations. These are just numbers for each one of the cases. That's all that is. The White House and my office didn't have this information earlier because we didn't know the senator from Missouri was going to make this claim in the first place. Once the Republican side requested the same information, my staff shared it within minutes. So now your side, Senator, has exactly what the White House and the Democratic side has. The same chart provided by the probation office. And I might add that some of this had been published in the press, in Washington Post and other places, but it consists in each case of the case number, name, the probation office recommendation for custody, the sentence imposed custody, probation office recommended supervision and release, and the supervision and release imposed. All of that information has now been shared equally. Some information on the other side, on the Republican side, includes frequent reference to transcripts, which we don't have on this side. And the reason being, we didn't anticipate this objection from the senator from Missouri and request that information. Now, the letter also goes a step beyond, which I think is a very important decision for this committee to make. This request for pre-sentence reports from each of these cases. Now, these pre-sentence reports are typically filed under seal. They can contain highly sensitive personal information, not just about the defendant, but about innocent third parties and victims. We've spent a lot of time here reflecting on these terrible crimes. Everyone has acknowledged how terrible they are and how damaging they can be to the victims. We have heard story after story, and I don't question a single word that was spoken in sympathy for these same victims. I would not want it weighing on my conscience that we are turning over these pre-sentence reports to this committee for the first time in history, and that information out of this, or because it was released, would somehow compromise or endanger any victim as a result of it. This information was not requested before. It's never been requested by this committee. And I think we ought to think long and hard about whether or not we even consider going into pre-sentence reports. So I'm going to take this matter up with our side, and I'm sure you will with your side. I have your letter requesting it. As far as this information, you have exactly what we have, no more, no less. In terms of pre-sentence reports, this is a critical policy question, which ought to be carefully weighed. It goes way beyond, I'm sorry, Senator Judge Jackson, it goes way beyond your nomination. And I want to make certain that we don't take a step here that endangers the lives or well-being of innocent people.
Mr. Chairman, since you just responded to the letter that I wrote and was submitted on behalf of 10 senators, I will point out that in Judge Jackson's answer to Senator Hawley, she said that he and this committee did not have sufficient information to assess her sentencing decisions because we heard the arguments of the prosecutors in the transcript, but we did not have the recommendation from the probation office. And what she testified under oath is you can't understand why she issued her sentences without having those probation reports. You are right that there can be sensitive victim information in those reports, and everyone on this side, I'm confident, would agree to redacting out any information that would violate the privacy of a victim. But Judge Jackson has told us it is relevant to understanding those cases, and that's why 10 of us have requested we have those reports, and there's explicit statutory authority for us to do so that is cited in the letter we just submitted.
Senator, I don't know where other members of your caucus stand on the basic question of this nomination. They can decide on their own, and they will, and they should. That is their responsibility. I think I know where you're headed. And I would just suggest that we ought to think long and hard, my friends, about members of the Judiciary Committee endangering the lives of innocent people to pursue this line of questioning. We spent 2 days, 15, 16, 17, 18 hours, and a large part of it on this issue. I don't believe these pre-sentencing reports are going to change anyone's disposition if they're going to vote on this issue. And I do not want it weighing on my conscience that I gave the green light to release this information so that it might endanger the lives of innocent victims. I'm sorry. That's a bridge too far for me. I think the issue before us on sentencing, you each had a chance to hear plenty of testimony on it. And I believe this should be taken up with the individual caucuses on both sides, if you wish. But that, to me, it's gone way too far. Way too far. I don't want it on my conscience.
Mr. Chairman, if I might,
Senator,
when I agree with you, I've prosecuted literally thousands of people. I would have to go back. It's over 8 years. I can't remember the hundreds of sentencings I was at where we had pre-sentence reports over and over again. There were things in there that were sensitive, sometimes reflecting somebody who were putting their lives on the line to even give a report. Neither the defense counsel nor I as a prosecutor ever thought those would be made public. And we assumed the judges, we had judges across the political stripes who read them, kept the confidence of that. As a result, we knew that the reports were thorough. And a judge has the final say, but as a prosecutor, I might have a recommendation, but I never question a judge who might give a different sentence, because my responsibility was to prosecute, theirs was to sentence.
Senator Lee.
Yeah, might I just weigh in here? I totally understand the concern that you're describing relative to the confidential nature of pre-sentence reports. As a prosecutor and as a law clerk, I reviewed those with some regularity, and I understand the sensitivity of them. Let me suggest a couple of things. First of all, it's not unusual for us as a committee and as members of the United States Senate to review materials that would be inappropriate for public release. I don't think one of us is suggesting that. There are means by which we can review things in a classified environment and treat them as classified. We've done that with significant success in this hearing. Secondly, to the extent that wouldn't provide the level of comfort necessary, we'd also be happy to review them on a redacted basis. These are things that have become relevant in our conversations. We want to make sure that we have the facts, but not one of us wants to endanger anyone or to render public information that is sensitive in nature. There are abundant ways around that.
I would suggest that the information contained in these reports is dangerous to the victims and to the innocent people who are mentioned in these reports, and unnecessary at this point. It's never been requested by this committee, and it's merely a fishing expedition in dangerous territory. Classified settings, redacted versions of the reports. This has never happened in the history of this committee. And I would say, Senator, I will just tell you, I am not going to be party to turning over this information and endangering the life of an innocent person for a political quest to find more information. We have exhausted this topic, and we've gone to it over and over again. And I think that this is a bridge too far for this committee. That's my personal feeling. I take it that Senator Leahy may agree with me in that regard. This nominee has been before this committee for 18 hours. I don't believe that this information is going to change anyone's vote. You can decide in your caucus what you want to do to go forward. I've told you my position. I want to proceed if I can. I thank the nominee for waiting for this colloquy, and I turn it over to Senator Cotton.